Nalini is there with us. In fact, even as Judge Nagarathna is reading out her opinion, and Nalini is going to break that down for us. She's deferred at least in one point. Explain to us and put this into context, Nalini.
Well, Sneha, what we need to understand is that all of these judges in this five-judge bench have held together that the centre, in fact, does have the powers to demonetize the currency notes of all series in case it requires to do so. What Justice Nagarathna differs on is the manner in which this is supposed to be done. Now, very categorically, like we just heard Justice Nagarathna speaking, she said, in her opinion, that even if demonetization has to happen, it has to specifically happen by way of legislation, because the powers of the government in this particular exercise are very vast. So because their powers are vast, it is important for them to take the approval of the parliament to get everyone on board and pass this only through a legislation or at least an ordinance, not by way of an executive order, is what Justice Nagarathna has said. But at the same time, what Justice Gavai, who was giving out his opinion earlier, has said is that there was consultation that was conducted between the centre as well as the RBI for at least 6 months before this final decision was taken regarding demonetization of the 500 and 1000 rupee notes. So even though all the judges have agreed on the fact that the centre does in fact have the power to go ahead and demonetize these currency notes, but at the same time, in the manner in which it is supposed to be done, the judges have differed on that, where Justice Nagarathna has said that in fact the centre should have gone the parliament route, they should have passed the legislation. On the other hand, Justice B.R. Gavai has said that the manner in which the RBI was consulted and the centre had passed this was done in the correct manner, and there is nothing apparently wrong with the process, at least on the face of it. It remains to be seen how many judges have agreed with Justice B.R. Gavai versus Justice Nagarathna and exactly what the split in the bench is going to be, but at least all the judges seem to be on the same page regarding the fact as to whether or not the centre has the powers to go ahead and demonetize the currency notes of all series or not.
The only differing point here is not her backing the process, but her backing the ban, but not the process per se. But all of them have in fact arrived at the consensus that indeed this was a move that was needed. Be with us, Nalini. I'm going to come back to you. We're going back to the live streaming of the court once again.
On such proposed measure. Proposal of the central government of a central certain scheme having serious economic ramification has to be placed before the bank to seek its expert opinion as to its viability of such a scheme. The bank as an expert body may render advice on such a proposal and on some occasions may even concur with the same. However, even such concurrence to a proposal originating from the central government is not akin to an original recommendation of the central board of the bank within the meaning of section 26, subsection 2 of the Act. Then I have gone through the affidavits of the Union of India and contrasted it with the affidavits of the bank. On a close reading of the notification dated 8th November 2016, in juxtaposition with the records, the following aspects emerge. One aspect of the matter which emerges with no ambiguity is that the proposal for demonetization originated from the central government by way of its letter addressed to the bank dated 7th November 2016. This aspect forms the central plank of the controversy at hand, that the recommendation did not originate from the bank under subsection 2 of section 26 of the Act, but was obtained from the bank in the form of an opinion on the proposal for demonetization submitted by the central government. Such an opinion could not be considered to be a recommendation as required by the central government in order to proceed under subsection 2 of section 26 of the Act. Even if it is assumed for the sake of argument that the said opinion was in fact a recommendation under subsection 2 of section 26 of the Act, in light of the interpretation given by me herein above to the phrase any series or any denomination, means specified series or specified denomination, the recommendation itself is void inasmuch as it pertained to demonetization of all series of banknotes of
Hearing from the court now, where the court is in fact spelling out in greater detail in the form of the new order on demonetization and the merits of the move. In fact, You just heard from Justice Nagarathna. We are going to go back to the live proceedings of court once again.
Interpretation would vest unguided and expansive discretion with the central bank of the board, or the central board of the bank. The legal principles applicable to the case, I have said that to do a thing a particular way or not to do at all, that is Taylor versus Taylor, Nazir Ahmed versus King Emperor, and the various cases of this court on the said principle are cited. What emerges from the above?
BJP's Amit Malviya is also now joining us. Your reaction to what has been said, 4:1 judgment in favor of the Notebandi move.
Well, the Supreme Court's judgment has only gone on to reiterate that the central government took a decision which it is well within its right to do. The Constitution of India provides a framework for central government to take economic decisions, policy decisions which are in the best interest of the country, and opposition using courts to settle political scores is something that is not going to find favor with the highest court of the country. Having said that, demonetization has had long-lasting impact on the country's economy. 5 lakh crores and more have found its way into formal banking sector. Today we have a very big digitized economic environment where billions of transactions happen over the internet, over several apps and online banking channels, making sure that we have a much larger formal economy today. It has incentivized the honest people who do their business with full disclosure, the poor who depend on transparency and who are the biggest gainers of a system that rewards and incentivizes honesty. The only people who were aggrieved by this entire demonetization exercise were the corrupt who had accumulated a lot of black money, illegitimate wealth, and the country has seen that the opposition was batting for such people. Therefore, the politics of the opposition stands exposed post this decision.
I also want to ask you, in fact, an important observation made by Justice Nagarathna, who continues to speak right now, is the fact that she's spoken about that there was no independent application of mind by the bank, referring to the RBI, in such an important issue is what she says.
Look, I don't want to...
Okay, in fact, we have a reaction coming in. Let's go straight to that.
बहुत कुछ इस जजमेंट के मुतालिक लिखा जाएगा और बहुत से जो कानून के जानने वाले लोग हैं इस पर टिप्पणी करेंगे, मगर आज मैं ये कहना चाहता हूं कि सरकार के फैसले को उचित ठहराया गया है संविधान की रूह से।
जो आपत्तियां दर्ज की गई थी उसको लेकर आप क्या कहेंगे? क्या वो आपत्तियां खारिज करना अब विपक्ष इस मुद्दे को उठाएगा नहीं, ठंडे बस्ते में चला गया है?
देखिए, विपक्ष को किसी भी मुद्दे को उठाने का अधिकार है, क्योंकि जो इतिहास जब लिखा जाता है तो वो एक फैसले से नहीं लिखा जाता। मगर ये बात सच है कि अब सुप्रीम कोर्ट के फैसले के बाद मैं समझता हूं फिलहाल इस मुद्दे को उठाने में कोई औचित्य नहीं है।
यानी अश्विनी कुमार जी ने साफ कर दिया है कि सुप्रीम कोर्ट के इस फैसले के बाद अब इस मुद्दे को उठाने का कोई औचित्य नहीं, कोई मतलब नहीं, कोई मकसद नहीं रह जाता है। फिलहाल विपक्ष के लिए या फिर याचिकाकर्ताओं के लिए ये बड़ा झटका तो है, क्योंकि कोर्ट ने, संविधान पीठ ने केंद्र सरकार की दलीलों को और इस अधिसूचना को बिल्कुल वैध ठहराया है और ये माना है कि सरकार ने पूरी प्रक्रिया के साथ ही नोटबंदी के लिए, नोटबंदी की अधिसूचना जारी करने से पहले, नोटबंदी लागू करने से पहले इस पूरी प्रक्रिया का पालन किया है।